we're honored to have with us today Bob Ferguson. It's always a pleasure to have Bob here. We're just talking about how many times he's been. I think it's at least 4 or 5 times now. And one of the reasons it's a pleasure is because a lot of folks don't know this, but Tom Foley, one of his first jobs out of law school was to work for the Attorney General's office. And I think he worked for John O'Connor.
That's probably right, John O'Connor. That's right.
In the early 1960s.
That's right.
And so it was. He always had a warm place in his heart for the Attorney General's office, and so it's a pleasure for us to have Bob Ferguson here, who now serves as Washington State's 18th Attorney General. He was first elected to that office in 2012. As Attorney General, Bob has instituted a number of reforms to the office, including creating the office's first civil rights unit, establishing a special unit to enforce campaign finance laws, creating a special counsel for environmental protection, and establishing an office for military and veterans legal assistance in order to help our service members. One of Bob's first major suits as Attorney General was against the Grocery Manufacturers Association, a group that represents companies like Pepsi and Coke and Nestle, for concealing millions of dollars in illegal campaign contributions. His suit led to a record penalty of $18 million against that association. Bob also recently won a unanimous state Supreme Court decision upholding the enforcement of Washington's anti-discrimination laws against private businesses that refuse to serve same-sex couples. Twice, Bob sued the Obama administration over cleanup and worker safety issues at the Hanford Nuclear Reservation. And more recently, Bob has sued the Trump administration, I guess, more than 50 times now, and successfully blocking the Trump administration's travel ban executive order. And then he's recently sued the administration as well to block President Trump's decision to end the DACA program. Given this record, it's not surprising that Time magazine names Bob Ferguson one of the 100 most influential people in the nation. It's my pleasure now to welcome back to the Foley Institute, Bob Ferguson.
Thanks so much, Pernell. It's great to be back at Wazoo. So thanks so much for having me. And first, Time Magazine thing, we'll get that out of the way first. So Time Magazine, they have this list every year, the 100 most influential people in the world. When I found out from my team I had made it, I thought it was an April Fool's Day joke. It was right just for April Fools. And so I got a phone call from one of my older brothers. I'm one of 7 kids. 6 boys, 1 long-suffering sister, my family of 7. And so I've got many older brothers. And the oldest brother called me up from California. He said, Bob, it's quite a promotion being selected as Time Magazine's 100 because you're not even the most influential person in our family. So that's what a big brother is for at a moment like that. Let's see, I guess before I dive in, it's great back on the campus. You mentioned Tom Foley, who was an assistant attorney general in our office right around 1960. He was part of a kind of fascinating group of folks who were attorneys back then, and includes, for example, it's a small office back then, more like dozens of attorneys, professional staff, instead of hundreds, more than 1,000 now, employees. But in his group of attorneys was a guy named Wing Luke. Wing Luke, if you go to the International District in Seattle, there's a Wing Luke Museum. It's named after Wing Luke, who was an individual who was actually also an assistant attorney general, served with Tom Foley, was a civil rights attorney in our office, and then he was the first Asian American elected to public office in the Northwest. Got elected to the Seattle City Council, died quite tragically in the 1960s in a plane crash. But if you ever have a free moment, Google Wing Luke. He's really a fascinating guy and a real role model in a lot of respects. So with that, I'm going to dive in. And so I think the plan is I speak for about 20 minutes or so and then leave it open for any questions you have. So feel free to ask about the cases that I talk about, but also feel free to ask anything at all, and I'll do my best to answer. Usual caveats apply. As the Attorney General, look, once in a while there's a case I'm asked about where I really can't speak about it. So as a general rule, if we have an investigation into an entity, we don't speak about that, whether I have one or what the content of it is. Other AGs will have a press conference announcing investigation. That's not what we do. If we have an investigation, we don't acknowledge it. So sometimes I'm asked questions about, hey, can you go after these guys? And I know we have an investigation going on, but I can't tell you that. So that's one. And number 2, advice we give to our clients, which is a big part of my job. Obviously, I can't share that. But most stuff we do at the national level, for example, or litigation we're bringing around opioids, those are my cases. I make those decisions. I'm usually pretty free to chat about those. So let's get started. Just real quick, I always like to have one slide about the AG's office. We're the largest law firm in the state of Washington, more than 600 attorneys, about that many professional staff. We have 13 offices all around the state. Pullman, I'll be in Spokane later on today, have one in Spokane. I work primarily out of our Seattle and Olympia offices, but we have 13 offices all around the state. And think of our work in two buckets. We provide legal advice to all the state boards, commissions, and agencies in the state, of which there's a couple hundred. Some are small, some are big, like Department of Corrections. They're a client, big client, complex legal issues you can imagine. Our role there and all of that work on behalf of the state is we give legal advice to the clients. They decide what to do. The head of Department of Corrections decides how to run that department. We give legal options. So it's like any law firm gives advice to you in whatever you're doing in your life. You decide what to do. You decide what goes in your will. The lawyer gives you advice on how to do it. That's our relationship. The other part of the work that I'll focus on here is work we do directly on behalf of the people of the state of Washington. So think areas like civil rights, consumer protection, antitrust, federal litigation that we have. Those cases are all my decisions to make. So if I'm filing a lawsuit against the president, I'm not calling up the governor to ask permission to do it. I may call to give him a heads up that I'm suing the president, right, as a courtesy, but it's not asking if it's okay, right? Those are my decisions to make and how to resolve those cases. So with that, let's get started. I think I'm going to focus on a quick overview of the federal litigation that Cornell just mentioned briefly. I'll talk about one case in a bit more detail. This is this public charge litigation, public charge rule, which is in the news, and I'll explain what that is. It's an important rule. An update on a case I talked about, I think last time I was here, or at least when I first filed it. It's a lawsuit related to 3D printed guns that we have going on. And I'll touch on Initiative 1639, which was an initiative passed by the voters almost exactly a year ago related to gun reform and some implications of that. So just a quick snapshot on the federal cases, because I know that has a lot of interest. We have filed now 50 lawsuits against administration. It's not, if you're married, isn't that like the golden anniversary? We're a long way. Colleen and I are a long way away from that. Is that the golden? So we didn't really have any observance in the office around that, but 50's a lot. 26 of those cases, just to give you a snapshot, are related to the environment, which a lot of folks don't realize, but we have a lot of litigation that's focused on that. That can range from rollbacks of fuel efficiency standards, that case is in the early stages, to rollbacks of protections under the Endangered Species Act, a case we recently filed, to the amount of pollutants that industry can put into our waterways all throughout our state. So a lot of cases related to the environment. Those tend not to be, with some exceptions, on the front page of newspapers. But cumulatively, what I would just say at a high level on that is, my view is the Trump administration is really systematically trying to roll back environmental protections, climate change protections, going back over many administrations, both Republican and Democratic, over many, many years, which explains the high volume of cases. 11 of the cases are, broadly speaking, immigration-related cases, healthcare. You can see the others. One thing I will just mention, it's not a case we have sued the administration against, but it's an important one, is that there's actually a lawsuit brought by Republican AGs against the administration saying that Obamacare is unconstitutional. So there's been one lawsuit already that went to the Supreme Court. The Supreme Court upheld the legality of Obamacare. New lawsuit brought by Republican AGs. The administration, the Department of Justice, their job is to defend federal law when there's a challenge to it, just like my job is to defend state law when there's a challenge to state law. Interestingly, the Department of Justice, when that case was filed challenging Obamacare in a Texas federal court, the administration said, no, we're not going to defend it. Go ahead, court, and say it's unconstitutional, which is an interesting choice. It's the job of the Department of Justice to defend federal laws, frankly, whether they like them or not. So they would not defend it. So we, the state of Washington, and other states with Democratic AGs went to that court and said, hey, if the federal government won't defend that law, let us come in. Even though we're not a part of the lawsuit, let us intervene. That's the word we use. Let us intervene in the lawsuit so there is a defense because of the implications for our state. If Obamacare is declared unconstitutional, the court granted that. So that case is working its way through the courts and will undoubtedly end up before the U.S. Supreme Court. So not a lawsuit against the administration. Somewhat oddly, we're actually defending federal law, in this case Obamacare, from a challenge from Republican AGs. And another case I talked about briefly before, this is just on the update side. Maybe when I was here last time or the time before, a lawsuit we have regarding DACA, which is a program that ensures dreamers in our country can remain in the country lawfully. Dreamers, as you know, are individuals who came across the border as children. President Obama created the DACA program, which allows those individuals, termed dreamers, to stay in the country if they meet certain criteria, of course. There's about 18,000 dreamers in Washington state. There would be dreamers on this campus, as you well know. There's about 800,000 dreamers across the country. It's a large number of people. The Trump administration, maybe now it's been 2 years ago, decided to eliminate those protections for those dreamers, to eliminate the DACA program, which had the effect of eliminating their legal status. In other words, those 800,000 people would be eligible for deportation. We challenged that, co-led a case with New York and Massachusetts successfully so far. So the only reason dreamers can't be deported right now is because of litigation, which has been successful putting a stop to that. But there will be an oral argument, which I think it has a date there, November 12th. Help me on the weeks, that's like in 2 weeks, I guess, if my calendar's right. So in 2 weeks, we're before the US Supreme Court to argue the Dreamers case. So it's a huge one, as you might imagine. An opinion would come some months after. You never know, it could be a few months, it could be 6 months. You don't really know, but that's a huge case for Dreamers that we've won at every level so far, but will now be argued at the US Supreme Court. So in summary on the federal, in the cases, we have 24 decisions on the merits of those 50 cases. So some are still being litigated, no decisions yet, right? About half are just no decisions at all. In about half, we actually have federal judges who have said, yep, up or down on the case. We've won all 24 of those cases. So the Seahawks are doing pretty well at 6-2. We're 24-0. So not bad. And certainly better than the UW and Washington State against Oregon this year, which we shouldn't even talk about, right? That's bad. Yeah, we share your, as a Husky, I share the pain. So 24-0, and that just gives you a snapshot. Feel free to ask. People often ask, hey, how do you win 24 straight cases against the administration? Short answer is it's not easy to win 24 straight cases against anyone in any context in the law. But short answer, the team in the office works extremely hard. The team's really good at what they do, as you might imagine. The folks who do this work are, they're excellent lawyers, excellent professional staff. These are folks who could all make a lot more money working in private practice, have a nice corner office with a big view of whatever downtown city they wanted, but they choose to work for you for $80,000 a year, $90,000 a year, $96,000 a year, and they can be making 5, 6, 7, 8 times that amount of money quite easily. So the team does great work. Number 2, in a courtroom, look, it's all a federal judge cares about is the law and the Constitution, the facts of your case. That's it. You can't tweet your way out of a problem in a courtroom. Federal judges really don't care about that sort of thing, right? So I think the playing field for a courtroom is to our advantage and works against the administration. And third, the administration is sloppy in the way they roll out a lot of these rule changes they want to do, or a lot of these executive actions. They just don't take the care and the thought that, frankly, I think these things deserve, and that gives us, frankly, opportunities for our legal arguments to help us bring the cases. There are many other reasons as well, but feel free to ask about that if you're curious. Now, I think this next one, there might be some audio, so we'll see how this works. So I'm going to move now into this public charge rule, and this is going to show you Ken Cuccinelli. Yeah, and he's the acting director of the U.S. Citizenship and Immigration Services. So he announced this public charge rule. If I click this, there might be audio. If not a big deal. Let me just try it. Didn't get it. That's no problem. So the public charge rule, let me explain what it is. It expands the definition of what they call a public charge to include any immigrant who uses public assistance to help get back on their feet or stay on their feet. So one thing to highlight, and I think there's a later slide, this rule applies to folks who are in our country legally. Okay, if you are not here legally, you cannot get federal benefits. Okay, so at the outset, these are folks who are here lawfully. They've got a green card, for example. Okay, they've got a student visa. They're here lawfully in our country. So there's a rule called the public charge rule that's been around a long time that says, basically, look, if you become wholly dependent on the state, the federal government, that can jeopardize your immigration status. That's what a public charge is. You're basically wholly dependent on the state for your wherewithal, for your resources, for your housing, for everything. So what's happened is the Trump administration announced a new rule recently that said the government can deport lawful immigrants who access public assistance even just for a very short time. It could be housing, healthcare, food, you name it. So it's a dramatic change that impacts many individuals in our country. So who does it apply to? Again, folks who are here lawfully. You got to be your visa holder, for example. You're a permanent resident. Does not apply, as I mentioned, to undocumented immigrants. So just as an example of how this applies, you have a U.S. citizen mother, applies for housing assistance for herself, her U.S. citizen child or children, and her non-citizen husband. He has a green card, for example. She lists her husband as a beneficiary of the housing assistance because he lives with them. That's what you've got to do. That will now expose him to deportation under this rule, this public charge rule. So it says the rule, importantly, does not just impact those who've received public benefits. Immigration officers can still deny visas or permanent residency to anyone they think may use these benefits in the future, even just for a few months. So it is extremely broad rule that impacts many individuals in our state and across the country. Just to give you a sense of how many people in our state. And this is kind of worth pointing out. Is I'm often asked, hey Bob, you're filing all these lawsuits against the president. What has that got to do with us here in Washington State? Why are you using resources in your office to go file a lawsuit against the president? Well, 18,000 dreamers are in our state. That impacts our state, right? If you're rolling back protections for endangered species, that impacts our orcas, right? These are things here in our state. Yes, the lawsuit is against the president, but those policies are impacting us and our lives and our environment every single day. So in this state, we have about 500,000 family members in our state, including immigrants and U.S. citizen children who currently use benefits, and they'll now have to make a choice. They'll know now if they access those benefits, even for a few months, a housing benefit, right, that will now jeopardize them in terms of being deported or a loved one to be deported. So that's literally a choice folks would have to make: housing, food. More than 140,000 Washingtonians would lose health insurance, including U.S. citizen children. Again, if you access that benefit under this new rule, you've now jeopardized your lawful status here in the United States. So we filed a lawsuit challenging that. Feel free to ask questions about how we choose to file cases or where we choose to file cases. I'm pretty free to talk about that, so if you're kind of curious how that works, how we work with other AGs, by all means, feel free to ask. This case we filed in Washington State. Some of our cases we filed in other states where we join other states in other litigation. But this is a good example of us leading a coalition of states in a lawsuit filed in Washington State. We actually filed here in the eastern part of the state, eastern Washington. It'd be a large, I should know how many states are on that case, but it's a large number of states have joined us on that. So always when litigation is filed against the administration, there is always a group of states that go together. Virtually, I'm speaking maybe too broadly, but almost always there's a group of states that file, and there's always one state, generally one state's chosen as the lead state. That's because you just can't have too many chefs in the kitchen, right? Choose your cliche. Someone's got to drive the litigation, essentially make the decisions, put the team in place to do it. But there's a strength in having a lot of states saying, hey, here's a problem for our state, and all the numbers I gave you, all those states can say, here's the challenge in our state with this new rule. But we're leading this particular case on behalf of a number of states, and we filed it here in the Eastern District of Washington. I think of the 50 suits we've filed, we're the lead state, I think at 18 of them. So that's a lot. The lead states are almost always Washington, California, New York, or Massachusetts. Once in a while you'll see another state, but for the most part, those 4 states are doing the overwhelming majority of the work on this litigation. So Washington, we're not just simply filing the cases, but we're find them here and lean them, and the work that goes into them is extensive, as these cases are extremely complex. I won't go into details of the legal arguments for obvious reasons. They get complicated in a big hurry, but the first one I think I mentioned there, the Administrative Procedure Act, often called the APA, which is as boring as it sounds, the Administrative Procedure Act, okay? And it's, think of the Administrative Procedure Act as, I may have mentioned this before when I've spoken, it's basically a law passed by Congress, bipartisan law, that says, hey, administration, hey, president, you've got a lot of power, right? But when you issue executive orders, like the public charge rule, you've got to follow certain basic rules around that. You've got to have a certain level of transparency around it. It could be public comments got to be taken. You've got to do a pro-con analysis of it. You got to explain why you're doing it. Doesn't mean people like the reason, but you got to say, here's why we're doing this. You got to be transparent about what you're doing so the public knows what's going on. The bar to meet the Administrative Procedure Act is relatively low for the most part, because it is procedural, okay? And I don't know how many of our 24 wins we've won because they violate the APA, but it would be a lot. Probably more than half. I'm sure more than half. And so the question of whether or not the citizenship question on the census, which went all the way to the U.S. Supreme Court, we won that case because it violated the Administrative Procedure Act. Basically, the court said you lied to us about the reason you want to ask that question. You can't do that. Okay. So the Administrative Procedure Act is sort of the equivalent of my kids are 11 years old. They do their math homework. They've got their math problem on the left-hand side of the piece of paper. On the right-hand side of the piece of paper is a bunch of white space. Sure. What that white space is for my kid to write out how they got to their answer. Okay, that way I know that Jack or Katie, and Katie would never do it, but Jack certainly would pick up my phone and punch in the question and get the answer and write it in, right? Jack would do it, Katie wouldn't do it. She's a rule follower. But that's what the APA is. Hey, administration, you got to show your work to the American people. So that is a key argument we have here, that they've not done a recent analysis or explanation, runs counter to all the evidence the agency has about the rule. I'll mention maybe this third point, so the Welfare Reform Act, so the bait and switch. So the federal law, as I mentioned, allows immigrants to apply for these benefits. I don't think I mentioned this, but after they've been here for 5 years. Okay, so there are limitations around this. The new rule essentially creates a bait and switch. If immigrants use public assistance to which they're legally entitled, right, they would then jeopardize their chances of later renewing their visa or becoming permanent residents. So we had a decision, Judge Peterson in the Eastern District of Washington, when we filed. And this is not unusual when we file our lawsuits. We often file for what we call a preliminary injunction, some sort of injunctive relief, which is saying to the judge, hey, before this rule goes into effect, put a stop to it, while you then have time to consider in more detail the arguments on the case. Now, getting an injunction is very hard to get, okay, for obvious reasons. You're saying to the judge, hey, before you have a chance to look at all the documents, look at all these motions and all that stuff, and have time to think about it, please put a stop to what the president is doing until you can make a final decision on the case. So injunctions in any context are always hard to get for that reason. Like one of the things you have to show is that you are substantially likely to prevail on the merits of your case once the judge gets to it. Well, that's asking a lot of a judge. The president's taking some action. We're in the court a week later saying, hey, judge, put a stop to that because we think the evidence is overwhelming, we're going to win, and there's going to be a lot of harm done to people of our state if you allow it to go forward in the meantime. Because it might take us a year before we get that final win. But in a year, a lot of people could be kicked off, right, lose their benefits and be kicked out of the country. So we actually got an injunction from Judge Peterson. So that is in place while the lawsuit goes forward. So the case is still before Judge Peterson, right? Things go forward. But the injunction's in place, which has put a stop to it. She issued that on October 11th. The rule was about to go into effect on October 15th. So I'm going to be brief here on the next one because I want to make sure I leave plenty of time for questions. So I know the last time I was here, I talked about a litigation we have on 3D printed guns. This is Cody Wilson. He's the guy who created, I think, owned this defense distributed entity, self-described crypto anarchist. So what this case is about are what's commonly referred to as ghost guns. These are undetectable, untraceable guns. Guns made using a 3D printer. The technology is that advanced where you can literally make those guns. Do they work as well as the regular gun? No. Can they shoot bullets? Yep. Can you get them past security at the Seahawks game? Yes. At an airport? Yes. So these are a major, major challenge. No serial numbers, no background checks, no nothing, right? You can download this stuff and you got a 3D printer and those things are getting more affordable all the time. You can print out a weapon. And they are very difficult to detect. As you can see, courthouses, you name it. And if they are used to commit a crime, they're very difficult to trace the weapon itself because there are no serial numbers, no background checks are done. So I requested a bill last year that actually restricts the possession of it. But before I get, which passed legislature. But this is not some sort of academic thing. I think the headline there says, Texas man with 3D printed gun and hit list of lawmakers sentenced to 8 years. I think he was in Texas, I want to say. I could be wrong, but I feel like that was out of Texas. I could be wrong about which state that was in. So we filed litigation challenging what the administration did. I left out a slide here, which I should have had in there, but just in brief, what the administration had litigation against that guy, who I showed you the picture of earlier. Let's see if I can go back to him here for a second. Yep. Had a litigation against this individual's company because he was wanting to put on the internet what's the word I'm looking for? Sort of the code to download the information of these 3D printed guns. Right? Here's how you do it. And you want to put that on the internet where anyone could just access that. So the administration, the Obama administration, challenged that and kept him from doing it in the courts. Okay, they're in the courts challenging that, federal courts. Trump administration comes along, continues that litigation, saying, yeah, in fact, the Defense Department saying how disastrous this would be for public safety, right? You name it. I mean, terrorism, you name it. This is a major, major problem. But at some point in the litigation, the Trump administration reverses course, settles the case with the guy, and allows him to post his stuff on the internet. For reasons that truly still escape me to this day. I mean, I just have no idea why the administration is doing that. So we filed a lawsuit saying, whoa, 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 don't let this guy post this stuff. And we've been successful so far. That's a case in the Western District of Washington before Judge Lasnik. So we've been successful with an injunction there that stops this guy's company from posting this information on the internet. So that's another example of one of those 50 cases that we have. I think the last thing I've got is a quick update on Initiative 1639. I think this is the last thing I'll chat about, and then I'll take your questions. So Initiative 1639 was approved by about 60% of the voters last year in Washington State. So what it does is, before the initiative, here's what the state of law was in Washington State. If you wanted to buy a handgun in Washington State, you had to be 21, okay? And when you walk into Cabela's to buy your handgun, there's a background check performed there, okay? And then the store clerk tells you, great, you've got a 10-day waiting period, Cornell, right, before you get your handgun, while a separate mental health background check is performed by local law enforcement. Okay, so you gotta be 21, and there's a separate background check done on mental health records, and there's a waiting period. You don't walk out with that pistol, you gotta wait 10 days. In order to buy an AR-15, for example, before this initiative, you only had to be 18 years old. And if you walked into the Cabela's to buy the AR-15, you walked out with it. There's no waiting period, and there's no separate background check for mental health records performed by local law enforcement, which seems like a, look, it didn't make a whole lot of sense to me. In Florida, there was a shooting in Florida where a teenager used a weapon like that, and the Florida legislature, Republican legislature, and Republican governor changed the law to say, well, if you have to be 21 to buy a pistol, now you be by 21 to buy that AR-15. I propose a change in Washington State law to do exactly that as well. Tried it in 2 different sessions in Washington State, with, by the way, Democratic majorities in the House and Senate, and the governor willing to sign it, couldn't even get it to the floor of the House or the Senate for a vote, by the way. So it didn't pass the House or the Senate in the state legislature in Washington. So the people actually took up an initiative and put it before the voters. 60% of the voters passed that. So that is now the law. What's happened since then, the initiative did other things as well. Obviously, I'm focusing kind of a couple key things there. What's happened from then is a number of local law enforcement officials have said they're not going to enforce the initiative. I don't know how many sheriffs it is, but it's a fair number now that, it might be half, it's a fair number of sheriffs have said they disagree with the initiative and they won't enforce it. So that's important because it's local law enforcement that enforces that separate background check, that mental health background check. So in other words, just to be clear, right, if a person is going in to buy an AR-15, the law requires that a mental health background check be done on that person before they get the weapon, right? Run against a database of people who should not have a weapon. So different sheriffs, I sent a letter to sheriffs saying, hey, just to be clear, you have a obligation to run those background checks. That's the job. If you don't do it, and a person gets an AR-15 who should not have one because of mental health reasons, and some tragedy happens at your local school, there will be lawsuits around that. Why didn't you do that? And ultimately, who's on the hook for that financially will be the taxpayers of your jurisdiction. And so besides having a tragedy that perhaps could have been avoided. So the way I sort of compare this to is, look, I strongly oppose the death penalty, okay? We've had a death penalty in our state. Our office actually handles death penalty appeals. So a local prosecutor brings a death penalty case, gets a conviction. When you get into what's called habeas appeals, my office handles those for all death penalty convictions. I oppose the death penalty. But literally my first week on the job, I met with the team that does that legal work and said, look, it doesn't matter what I think about the death penalty. Keep doing your work. Keep doing it. You want to talk about a case, come talk to me about it, but go forth with your work. My job is to defend and enforce Washington state law, whether I agree with it or whether I don't agree with it, right? And I did not view that as discretionary. I could say to a local prosecutor, hey, thanks for bringing that case, but you know what? I really don't like the death penalty, so sorry, not going to do it. I think it's appropriate for me, though, to seek a change in the law, which I've done with the death penalty. I've sponsored legislation to abolish the death penalty in Washington state. I've encouraged these sheriffs, hey, if you don't like Initiative 1639, file a lawsuit or join the lawsuit. There's a lawsuit challenging it. That's fine, right? Or seek to change the law. Go back to the legislature and say, hey, 60% of the voters had it wrong, legislature. Would you change it back to the way it was? Those seem like the appropriate steps to take, not saying, hey, I'm not going to enforce the law because I disagree with it. So that's been in the news lately, and we'll see what happens with that going forward. I'm going to skip this last slide, which is some further conversation about that, and open up to any questions that you have. Who wants to go bonus points? Thanks. The first question right up front, yeah, go right ahead.
I have a question about what the state's relationship is, if any, to the Northwest Migrant Detention Center in Tacoma.
So good question. I'll repeat the question. So the question is, what's the state's relationship with the Northwest Detention Facility, which is in Tacoma, Washington? The entity, the detention facility, is owned by a private company, the Geo Corporation. Okay, so it's owned by a private corporation. It can house up to about 1,500 individuals who are facing civil deportation proceedings, right? They're not being held for criminal violations, they're civil deportation proceedings. Many individuals who go through those proceedings are then sent back into Washington State because they can be here legally, right? So not everybody who goes in is then deported, right? But it's owned by a private corporation, so it's not a state-run facility, just to be perfectly clear. There have been some issues with the city council looking at Tacoma, putting in some. There have been proposals to put some restrictions around that facility, but I'm no expert on what the city is doing. We have litigation against the Geo Corporation, in the entity that owns that detention facility, because we believe they're violating Washington State's minimum wage laws. So in Washington State, you gotta pay minimum wage, as you all know. There's an exception for that for state-run prisons. So if you got a felony and you're in a state prison and you're helping make license plates, you're not paid the minimum wage. State law exempts the state if you're running a prison, right? There is no exemption for a private for-profit corporation that runs a detention facility, right? To not pay minimum wage. And what the Geo Corporation does there is that much of the labor performed at the detention facility is actually done by the individuals who are there awaiting their deportation proceedings. And they are paid $1 a day, or they're paid in candy bars and chips. And so that saves the Geo Corporation many, many millions of dollars, right? That they're not paying a minimum wage to those folks. It also deprives people in the workforce outside the facility who could do that work there, right? If they're paying a minimum wage, right? There are workers who go in and do that work. So we filed litigation against the Geo Corporation. That's been lengthy, drawn-out litigation, but we have survived motions to dismiss and all that, and are heading to a trial. So that case is still being litigated. So we do have obviously a role if we feel they're violating state law, right? They are still subject to state law in our view, just like any businesses in Washington State.
And it's government that determines who goes into that facility, then.
The federal government.
Federal government.
So they contract with the federal. I think it's the right phrase that they are in a contract relationship with the federal government. That's correct. Yeah. Yes.
Could you repeat that? Who are they paying $1?
They're paying the individuals awaiting their deportation proceedings, their immigration proceedings.
Oh, okay.
Right. So folks who've been picked up on suspicion of, hey, they're not in the country lawfully.
Okay.
There are about up to 1,500 folks who are there. Those folks do much of the work, right?
Oh, okay.
Those individuals, and they're paid the $1 a day or the paid in chips and candy. So look, if they want to hire those folks to work, great, pay minimum wage, or hire some from outside the facility to do that work, right? But you can't run your business and not paying minimum wage for folks who are in the labor there.
Okay.
Yeah. Yeah. Thanks for clarifying. I'm sorry if I wasn't clear on that. Thank you. Yes.
Could you speak about that lawsuit against 1639 and the state's defense?
Yeah, so there is on Initiative 1639, the initiative passed by the voters. The NRA has brought a lawsuit challenging that initiative in court, which is typical, right? That happens all the time on anything that's all vaguely controversial on the initiative side. There's almost always a lawsuit. Our job, by the way, is the AG's office. We defend initiatives, all initiatives that are passed if there's a lawsuit. So there's not a ton I can say in terms of an update because while there's been a lawsuit filed, there's been no sort of major decision by a judge at this point. We're still in the early stages of it. What I will say is that we believe it to be constitutional, and we think the courts will ultimately uphold it. It's the kind of case that I wouldn't be surprised if it ends up before a state Supreme Court. It's an initiative, and the other side is, I think, intends to litigate it, which is absolutely their right. So, do they have a range of claims against it? Obviously, so I'm not going to make their arguments for them here, obviously, but it's in the early stages of litigation, so the judge has not made any substantive decisions on the case so far, and it may take some time before we get to that point. And then, of course, whatever outcome it is, it'll be appealed on up. So, one thing I would add on that is, like for the sheriffs who don't want to enforce it, every law is presumed constitutional until a judge says it's not. Right? The public charge rule was constitutional until Judge Peterson said, nope, injunctions in place. Right? Up until then, Washington State had to live with it, right? Whether we liked it or not. So that's the way it is for any law, right? It may be controversial, people may think it's unconstitutional, but until a judge says it violates a law, it's what we say, presumed constitutional. Everybody's got to follow it till that time. So if I'm invited back next year, I'll probably have more of an update on kind of where that litigation is going, because it should be further along by then. Yeah.
So in light of the ongoing impeachment inquiry against the president, I want to know your opinion, not personally, but as a lawyer. Do you think that the merits of the case for impeachment in terms of the Ukraine dealings, do you think the merits are there to impeach the president? And do you think that outside of this immediate situation with Ukraine, are there other impeachable offenses such as violation of the Emoluments Clause or violation of the War Powers Act in relation to Yemen?
So impeachment, so a couple things. So one is, I don't spend as much time following that as you might think that I would as a lawyer and as the Attorney General. It's not that I'm not interested, of course I am. But, honestly, I'm so busy with my day job and having 11-year-old twins that it pretty much occupies all the bandwidth I've got, and to be just being perfectly honest. So yes, of course I kind of follow, but I don't read nearly as much about it as you might think. And so what I would say is that, on the Ukrainian side, look, obviously I find it deeply troubling, right? But I do not pretend to be an expert on that. I've not read all the documents on it. So, to weigh in on from a legal side, I just couldn't do it because I've not read those documents. But look, do I think it's deeply troubling? Yeah, I do, to put it very, very mildly. On the emolument side, I can say a little more about that because there's actually litigation brought by a couple AG attorneys general taking on the administration for a violation of the Emoluments Clause. There's actually a lawsuit that's brought by the attorneys general of District of Columbia and Maryland, Brian Frosch and Carl Racine. And so this goes, the Emoluments Clause is an previously obscure provision in our Constitution, which I won't worry with. Basically, the president can't profit from his or her time in office, right? So the idea is, hey, the Trump administration, the president rather, has hotels, for example, right? And if people are being steered to those hotels because he's the president, he's personally profiting, that violates this Emoluments Clause. I'm oversimplifying terribly, but I think you get the concept. So we're not a part of that lawsuit, in part because there's not Trump holdings here in Washington State, as opposed to the District of Columbia and Maryland, where you have hotels and that type of thing. So that litigation has been brought by those AGs, and that is just still ongoing. So I'm no expert on that as well. Those AGs are good AGs. They feel they have a strong case, but the courts will eventually say what needs to be said on that case. So, do I wish I had more time to track the proceedings back in DC? In a way I do, but I guess just overall my philosophy is, for what it's worth, is I tend to focus on things I have control over and don't worry about things I don't have. Don't say don't worry is too flip, but I focus my energy on things I have some control over, right? And with 50 lawsuits against the president, when it comes to things going on in DC, that has my full attention and takes a lot of my focus to make sure I'm making good decisions about those cases. And so often at the end of the day, and I get home, before I go to bed, I kind of log on CNN and check out the headlines, but it doesn't get a whole lot further than that, which I realize is sort of surprising for a person in my job, but it's yeah. Yes, you have a question?
Yeah, can you speak to the First Amendment issue with the 3D printer? The idea that, and I don't agree with the guy.
Yeah.
But does he have a First Amendment right to send out that recipe?
Sure. So that's an argument that they have is, hey, this is a First Amendment issue. It's free speech to put this information out there, and like all of our constitutional rights, there are limits to them, right? No one here can stand up and yell fire. There's not a fire. Classic law school example, right? Because that could cause a problem. People are stampeding out of here, right? That there can be a problem if that happens, right? So there are limits to that, and so far the courts have, on the scale, right, of what someone can just say, right, versus balancing out other rights as well, they've come down pretty clearly and saying, no, that's not a First Amendment right. Or maybe a better way of expressing it is, hey, public safety concerns and others override that claim. So I don't expect that to change with that case. We feel it's a pretty strong case for us, and so far the courts have gone our way. But that is the argument that is being made out there is, hey, we should be able to put this out there to anyone. Yeah, but so far the courts have not agreed with that. Yes?
So knowing how DACA was implemented during the Obama years and the reasons why the Trump administration wants to return the program, what do you expect from the Supreme Court decision on the issue, and what would the state's reaction be if the Supreme Court were to back the decision and a federal order would come down to start removing those individuals?
So I'll repeat the question. So the question goes to the Dreamers case. That's before the U.S. Supreme Court in just a couple weeks. And kind of asking what I think is going to happen, I think, was part of the question. Also, how would the state respond if the Supreme Court rules against us? We've won so far, right? But the Supreme Court says, no, states, you're wrong. The Trump administration can eliminate that program and then begin deportation proceedings against those individuals. How would we respond to that? I guess a couple thoughts. So in terms of the case itself, these things are really hard to predict, right? And I try to avoid predicting them. The court is a conservative court now. That's just a statement of fact. But I think we have really strong arguments in this case. And I think it's why the federal judges so far, there have been a couple different cases, but all the federal judges so far I looked at have agreed with the states on this. So, obviously I'm very hopeful that the court will go our way on this. But there's no guarantees, obviously. So if the court goes against us, I think it's sort of premature to say what the state would do, in part because, how about taking out of the context of Dreamers for a moment, but immigration policies are, how about this, the federal government has a lot of authority when it comes to immigration, right? They do. They have a lot of power when it comes to immigration. You see it on the news, right? The raids that go on stuff, they have a lot of discretion on how they want to do it. Whether you or I think it's the right thing they're doing or the wrong thing, they've got a lot of discretion on how they conduct and enforce their immigration policies. So it's not like a state can, I don't want to speak about Dreamers specifically, right? But just in general, it's, states have a limited role in stopping the federal government from enforcing their immigration laws. They have the power to do it. That is different than saying, you read a lot about sanctuary jurisdictions, sanctuary cities, sanctuary counties. What that is where a local government says, hey, we're not going to do your work for you, federal government, when it comes to immigration, right? We're not going to turn over information to folks we don't need to turn over to. If you want to come in and do your work, fine, that's up to you. But we're gonna provide what we need to provide, but no more, right? That's what's kind of often called a sanctuary jurisdiction. No two sanctuary jurisdictions are exactly alike in kind of what information they share or don't share, but that is different than the power that the federal government has to enforce immigration laws. And so, as long as they're following those laws and doing it, they have a wide discretion with that. Whether the administration would start deportation proceedings against Dreamers, you would hope not, but I'm not confident of that. And I'll give you one example why. When the DACA program was created for Dreamers, right, it was really contingent upon or required potential Dreamers to come out of the shadows, right? These are folks who are not here legally, they came across the border as kids. So the first step is you have to say, hey, to the federal government, I'm a potential dreamer, I'm not here lawfully. You have to come out of the shadows and tell the federal government, the very entity that has the power to deport you, that you're here illegally, right? In order to encourage people to take that step and start the process of potentially qualifying to be a dreamer, the federal government promised that they would never use the information those dreamers provided, those potential dreamers provided to the federal government to deport them. There's even a website about the DACA program, Q&A's, question and answer section on it. One of the questions is, hey, will this information ever be used against me to deport me if I give it to you, federal government? Answer, no. The federal government will never use this information you provide us to be a DACA recipient against you to deport you. On the day the administration revoked protections for DACA, for Dreamers, that question and that answer on that webpage was taken down. So, so you'll forgive me if I'm skeptical that the federal government won't start deporting Dreamers the day after the Supreme Court issues a decision that's adverse to the states if it goes that way. So, I've got a lot of thoughts on it. What I have to just say is, so look, would we review what our options are? Yes, of course, like we would for any situation. I just want to be realistic and clear about it, right? That federal law is federal law when it comes to immigration, and the government has a lot of authority, and elections have great consequences. I just have to be mindful of that and the role that we have. And it's just to add a thought to that. One more thing I'll add to that is, it's in the 50 cases we have, one thing I've come to appreciate in thinking a lot about all that litigation is, of course, I've talked about these cases are hugely significant for Dreamers in this case, or our environment, or folks who might be getting benefits who have a green card who might now be deported because, right, they got a housing assistance. I've also come to understand that cases are, go to, I think, fundamental American values, I think, are being expressed in litigation. And the Dreamers one's a good example, right? The federal government made a promise to these individuals not to use that information to deport them, right? And yet they've made no assurance now that they won't go back on that promise. And, I think a deeply ingrained American value is a deal, right? And, I sometimes say for my son Jack is into Pokemon cards. He loves Pokemon cards. I don't really understand Pokemon cards, but he's got them. He trades them. They have different values. I don't really quite get what it is. I have baseball cards, but he trades Pokemon cards and he collects them and he buys them. He loves them. And he trades them with his best friend Elliot. Well, he comes back from trading Pokemon cards with Elliot one day and says, "Dad, I just realized I made a really bad trade. I traded a really valuable Pokemon card. For when it's not so valuable, we got to go back up to Elliot's house and get it back." What am I going to say to him? "Sorry, Jack, not how it works, right? You made a deal. You may not like the deal now, I get that, but you made a deal and you need to stick to it." I'm convinced every parent teaches their children, as soon as they think that child can comprehend the concept of a deal's a deal, you communicate that to your child. It's that important, right? Well, with Dreamers, we're not talking about Pokemon cards, right? It's where they can live, for God's sakes. I was just texting with a Dreamer yesterday, talking about this case coming up. The country she would be deported back to, she knows nobody there. Go back to what? There is no there for her. This is her country. She came here as a kid. It's only goes to school, works. This is her whole life is here, right? Many Dreamers don't speak the language. It'd be sorry I'm going on the long, but it'd be no different than, hey, my family were German and Irish ancestry. It'd be no different than I came home tomorrow when I get home tomorrow night and said to Jack and Katie, "Yeah, really sorry kids, but we're going back to Germany." They'd be like, we lived in Germany? Yeah, when you were 2, we came to the United States. We don't speak German. I'm really sorry about that. We don't know anyone in Germany. We have a school here. It's our whole life here. Dreamers are everybody as American as Jack and Katie. Take my word for it. They are. So the idea that, the administration is contestants in court and not assuring Dreamers they won't use that information to deport them, and just given past practice and the way they've run their immigration proceedings, I just would have to believe that they would undertake immigration proceedings against Dreamers, as painful as that would be. But hopefully the court won't reach that. How about this? All the cases are important. I do not want that case to be so. And maybe I'll make this the last one because it'll take a few minutes to kind of get through it. But this is hugely important and been in the news a lot. Litigation brought by AGs around opioids. So just to sort of set the table a little bit for opioids, I think everyone knows academically it's a crisis in our country and our state. But just put a number on it. On average, in Washington State, 2 people die of an opioid overdose every day. So let me clear, they don't have the overdose and survive it. They have the overdose and they die. Every day, 2 people every day. And there are enough opioids prescribed in Washington State back, I think it was in 2015 we had numbers. There were enough opioids that year in Washington State for every man, woman, and child. So Jack and Katie count, right? For every man, woman, child to have a 27-day supply of opioids. That's a lot of opioids out there in our communities. So we, in our office, have been pretty aggressive on litigating cases against entities that we think have especially fueled the opioid epidemic. So we were one of the first states to file a lawsuit against Purdue Pharmaceutical, owned by the Sackler family. You probably read about them in newspapers a lot lately. They're the manufacturer of OxyContin. We believe they downplayed in the extreme the addictive qualities of OxyContin in the pursuit of profits. That case is now in bankruptcy. Purdue's applied for bankruptcy. And so we'll see what comes out of that. The other case we have are against 3 distributors of opioids, and these 3 distributors are Fortune 15 companies. These are huge corporations, and they distribute opioids into communities. And they have a legal obligation if they see a suspicious order. So let's say in Pullman, if you see a huge number of opioid orders in a relatively small town like Pullman, well, wait a second. All these orders coming in disproportionate to the population, that's a red flag. If they see that, they have a legal obligation not to ship the opioids and to notify the authorities. That's a legal obligation they have as distributors of opioids. Those 3 distributors distributed more opioid prescriptions, so not pills, right? More prescriptions than there are people in more than a dozen counties in Washington State. I know Spokane County is one of them, for example, right? This county maybe when I have to look at my list, right? But red counties, blue counties, rural, urban, think about that. More prescriptions than people in a dozen counties. It's hard to wrap my mind around that. So we have litigation against those 3 distributors. Our trial with them is less than a year away. Those cases, these are huge cases, billions of dollars. Harm to our community and individuals is profound in the extreme. And so, you know, what I can say is that there's been a lot of litigation filed by different states. Washington is almost unique. I don't want to quite go as far as saying unique, but almost unique in that we are litigating those cases. A lot of entities file a lawsuit and kind of sit in the lawsuit and wait for a settlement to happen. We're moving forward. There's a team. We've got a trial date in less than a year. We're going to trial. And the reason I haven't taken a settlement so far in the Purdue case or the distributor cases is, you know, having spoken to a lot of parents who lost their kids to the opioid epidemic. Yes, money is extremely important, right? Money will help with people who are suffering from addiction, get treatment that they need. We do not have enough resources in the state for that treatment and prevention, right? I'm not minimizing how important having millions of dollars can help with that. But, you know, most of the people I talk to have been directly impacted by it, as in like a kid has died, or they've lost the kid, not physically, but the kid is no longer, that their child's caught up in really the ravages of addiction, and it's not the child that they knew. What I would say is that for them, so many of them have said, hey, you know what I want? Like, what I want is to go to, we filed in King County Superior Court. I want to go to downtown Seattle, walk into a courtroom, and see the executives of those companies explain how they distributed more opioid prescriptions than people in my county. How'd they do that? I want all the documents that we have. Many can't be disclosed because under seal while litigation is going on. But there's a trial. All of you can see what Purdue knew when they knew it and what they were saying publicly when they had information to the contrary. So there is also a value beyond money that is transparency and accountability for the public and for those families. Now, how do you balance all that, right? Not easy, right? And so I've said to my team internally, I think this to be true, is that of all the cases I've dealt as Attorney General, I think this is true, that the opioid litigation and sort of the decisions around that, whether settle, whether not settle, whether trial, what to do, I think, and they're just complicated as hell cases, by the way, I think are probably the most difficult decisions for me as Attorney General, my time as Attorney General. The Trump litigation, yeah, those are challenging cases, but I think they're just complex, the opioid litigation. And so the way I try to handle difficult decisions is, in some ways, is to, it's easy on difficult decisions to kind of wrap yourself around the axle. What if this, what if that, what if the other, and you just spend all your time not coming to a decision. In some ways, the more difficult the decision, I try to make it more simple in a way. And so for me, with the opioid cases, I've just decided that transparency, that accountability, having that courtroom where those executives have to show up, that's the most important thing, right? And that everything else is important too, don't get me wrong, but that's the most important thing. And so the team just knows we're driving to that. Doesn't mean I wouldn't take a settlement if I thought it was the right thing for the state at the right time, but the team knows we're litigating, we're going forward, and we're putting resources into that. So, yeah. Hey, thanks so much, everybody, for having me today. Really appreciate it. Yeah,